What happens before the appraiser? I mean, what's like the first notice that you get from the DOT or TECO or Florida Power that they're coming for your property, or they may be coming?
So some governments will send a letter they call it something, it's usually entitled something like "Coming Your Way," that is like, we think we're going to be coming to take some of your property. Eventually, and they usually send this pretty close to when they're going to send an appraiser out. Now, it's government time, I say pretty close, maybe 2 or 3 months before they're going to send an appraiser out. The property owner usually gets a letter from the appraiser that they hired saying, "This is the day I want to come and inspect your property." Sometimes there's a notice in the newspaper or online that a government is having a public hearing about a project. So some clients find out that there may be a taking from their property that way. Sometimes it's just gossip in the neighborhood. Somebody says, "Hey, did you hear they might be widening the road in front of us?" Sometimes they get notice from a lawyer or an appraiser who says, "Hey, we see that Florida Power is going to do this project," or Polk County or Okeechobee County, or it could be any variety of governments. So for some people, the process starts at that point. And so that is, there may be a taking. And so that's when I get somebody calls me, a client calls me, because now it's real to them.
Somebody's coming to my
house.
Somebody's coming to my business.
And of course, most people, which is wise, no matter what their property is, don't want to be there without a lawyer. They want somebody to represent them. And sometimes they hire me and I go, and they don't want to be there. Well, they don't have to be there if they don't, I'm the buffer, so to speak. Then normally what happens is they sign a letter to hire the lawyer. And normally, I have two types of clients. Some clients say to me, "I want you to come out not right now, but in the next month. I want you to come look at my property." Of course, I go look at their property. Sometimes they have clients that are out of state and they say, "I'm not going to be in Florida for 9 months. I'll set up a time to go look with you at the property or meet at your office." I let the clients direct that. The next step in the process, the official process, is what we talked about before, which is a notification letter from a government that they're going to send an appraiser out to your property. Then you get an official letter based on their appraisal, how much compensation they're offering you. If they're going to take it to file a lawsuit, they must give you a written offer. It has to be based. It can't be lower than their own appraisal. So that's one good thing. They can't get an appraisal that says $100,000 and offer you $50,000. They have to give you the same amount that their appraiser says. And then if you don't negotiate it in that period, Florida law requires them to negotiate a minimum of 30 days before they can file a lawsuit. Now, a lot of people get, when I talk to them, they're worried about the lawsuit. And I'm like, "You're not paying to file a lawsuit. You don't have to go to Bartow for the hearing. I can go to Bartow for the hearing about whether or not they can take your property." And most of the time, there's not an argument about how much property is being taken or whatever. But if there is, I then appear for them at the hearing and get witnesses. Now, sometimes the property owner wants to be at the hearing. I mean, that's fine. But if they don't want to be at the hearing, I can represent them. Some people who don't hire a lawyer will say, "Okay, I'll take that offer." I don't know why anybody would take the first offer, but they do. And then some of those people go to a closing as if I was selling my house to you. There's a closing that's done and the case is over. But I would say most cases, the lawsuit is filed. There may be the order of taking hearing if there's a question about whether it should be taken or the size of the taking or the location of the taking. In most cases, the property owner ends up agreeing that they can take the property. They just don't agree on the price. So then the government gets an order that they own it. They make a deposit for their appraisal amount that person can draw out of the registry of the court if, or maybe I should say, unless they have like a mortgage where the lender's supposed to get the money.
Right.
It's a whole other story of why you need a lawyer. And after that stage, there's usually a mediation or a jury trial. There's only two paths to conclude the case on how much you get paid. You either settle it with them, you both can agree to a number, or there's a jury trial.
The jury decides.
And the jury decides. There is no other option. Then you have to mediate before you go to a jury trial. So I would say the bulk of the cases settle at mediation. And, we pride ourselves on doing a good job at mediation. We want to be prepared. We want to it's your opportunity to explain to the government what they're going to face at a jury trial if you don't settle. And so I believe it's very important to really be prepared at mediation. Part of what happens, it's not like the people in the government are bad people. Sometimes they're just overworked. So, they say they have 150 parcels of land they're supposed to acquire. They don't know about you're losing half your parking and what the problem is for your business. So when we go to mediation, we've got their attention. And I think that's why most of the cases end up settling at mediation, that we can accomplish that because we can really give them a good picture of what they're going to face at trial if we don't settle.
Now, mediation it's not arbitration.
No, they can't. The mediator can't make you take a number.
It's just a settlement conference.
Yes.
And you are a certified mediator.
And I'm a mediator. Yeah, I get asked to mediate eminent domain cases. Nobody would want me to mediate their divorce case or personal injury case. But because I have had the opportunity to represent both sides and have done this for such a long time, I've also been a mediator on other people's cases to try to help both sides. So I think that helps me have some insight into how mediation works, but also how important it is for the property owner to have somebody represent a very clear picture of their case. Because often on the other side, they're just too busy to be up to date on it.
We, the lawyers, the adjusters, and the Department of Transportation, we have hundreds of cases between us. This person sitting at the table has one.
Right.
Mediation to me is very important because you have the decision makers sitting there at the table with you. And so you have to be in a position to educate them about the case because they have hundreds of cases.
Right.
And you have to educate them that this case has merit. This case, when we go to trial, is going to be a problem for you. Here's your opportunity to get the case settled.
Right. So that they see it as the individual's problem and it's real to them. And sometimes there are just cases where the facts are kind of quirky. And I had a case once. It was a certain type of horse. It was a horse farm. And my client, very nice people, told me that their land that was very low and wet, that was an advantage for the horses. Well, people who deal with land like I do in these cases, typically when land is wet, that's a disadvantage. So I'm thinking, well, let's check this out. Well, I'll be darned. I actually got a horse expert in the type of horse. They came and looked at the property and they explained to me in very compelling terms that because it was damp, it grew a certain kind of grass that they could feed the horses, which saved them all this money from buying feed that we could quantify. Like we could say, this is how much less feed I have to buy. And then I found out there were certain chemicals wouldn't be the right word.
Like minerals.
Minerals in that particular soil that made the grass more beneficial to the horses. Now, to be frank, when I started, it sounded like a bunch of hooey. I'm like, what? And then it turns out it's true. But I had investigated and I had witnesses to persuade the government. So we were able to settle the case satisfactorily because I could show them that it was true, even though it sounded kind of strange, but it was all true. And that's also part of what happens sometimes. I'm sure it happens in your PI cases sometimes. There's probably an unusual injury that doesn't fit something typical. And so it's our responsibility as the lawyer to show why it's different than other cases.
Yeah. And to show them that, look, when we get to trial, this is not going to be a good day for you.
Right.
When you were talking about the horse case, it reminded me of your RV park case, where, there was some strange land use issue. So you had to have a land use lawyer involved. And there was an issue about how many RV spaces they had, or mobile home park spaces they had. And they were grandfathered in under some sort of lawsuit that had been filed 35 years ago. And we had to do all the research and brought all that to the mediation. And the case settled for multiples of what they'd offered previously.
Right.
Florida has 67 counties, I think.
Yes.
The last time I counted, I had cases in 37 of them.
Wow.
What areas are you practicing in eminent domain?
Most of my cases do end up being in Central Florida. I've had a lot of cases in Osceola County, Okeechobee, Highlands, Hardy County, eminent domain. As I said, it's a relatively small amount of lawyers. And then there, for instance, in Okeechobee County, there really aren't even that many lawyers in Okeechobee, period. Right. So it's definitely no eminent domain practitioner in Okeechobee County. So that's why I think over the years I've done a lot of work, for instance, in Okeechobee.
But my memory is you've gone into Osceola, Seminole, Orange, Hillsborough, Pasco, all up and down the I-4 corridor.
Yes, all up and down the I-4 corridor. Another reason that property owners should get somebody who has background is even the judges who hear these disputes, which is totally understandable, often don't have a grasp of eminent domain law. It's such a narrow specialty that often when you're dealing with the judges, who, by the way, I've found to be great across the state of Florida, but often what I hear from the judge is, I've never had an eminent domain case, or I never had an eminent domain jury trial. Is there anything unique about it? And you say to the judge, well, it's not 6 jurors, it's 12. It's jury view. In eminent domain cases in Florida, they put the jurors on a bus or some kind of method of transportation. They take them out to your property. They're going to see your property. Well, a lot of times even the judges don't know that. They're like, what? And I'm like, well, we got to prepare for that.
Well, you're also entitled to an expedited trial.
Yes.
Which is unusual. I mean, in a lot of cases, in a lot of counties, you want a trial, you can, okay, fine, you're set for the 12th of never.
Right.
Not in eminent domain.
And that is one of the good things. And I always try, once the lawsuit is filed, I can't promise I always do it, but I endeavor to have their case concluded within a year. And most trial lawyers like you would say to me, well, Deborah, how could you do that? Because how could you get a jury trial in a year? But because of that expedited process, you can get a trial within a year in eminent domain in most counties in Florida, which is an advantage that the property owner has. There are occasional bright spots where the person really comes out well. And that's the goal, of course.
I would call it frequent rather than occasional.
Oh, thank you.
My experience with the clients that you've had.
Okay. Well, thank you. I appreciate that.